All right, it's 2 o'clock already, and I think, Mr. Max, do I have your go-ahead to commence?
Yes, please carry on, Samuel.
All right. Thank you so much. Good afternoon, everyone. My name is Samuel Fagade, and I am privileged to be moderating this webinar. It promises to be very insightful and very intellectually stimulating. This webinar is tagged the Construction Law webinar, organized by the Engineering, Construction, and Real Estate Sector Interest Group of the Chartered Institute of Arbitrators, Abuja Chapter. And I count it a huge honor and privilege to moderate this webinar. And this webinar is graced by very seasoned and erudite lead speaker and discussants. I would introduce them very shortly, but before I do, I would like to recognize the presence of the chairman of the Chartered Institute of Arbitrators, United Kingdom Nigerian branch, in person of Chief Gola Akinola, SAN, Chartered Arbitrator. I also want to recognize the presence of the chairman of the Chartered Institute of Arbitrators, Abuja Chapter, Honorable Shola Ifeyin Oluwanuga, NNI, Chartered Arbitrator. Thank you so much for joining us, sir. It's very good to see you, sir. We also have the chairman of the Engineering, Construction, and Real Estate Group of the Chartered Institute of Arbitrators, Abuja Chapter, Engineer Ibile Okeke, FCIArb, OON CFR. Thank you so much for joining in, ma'am. We equally have the chairman of the Construction Law Webinar Planning Committee, in person of Mrs. Roslyn Wosu, FCIArb. Thank you so much, ma'am, for joining in. We appreciate you. And I also want to recognize all the members of the planning committee of the Construction Law webinar. I recognize the lead speaker, Mr. Aninda Mitra, the senior contract specialist. Thank you so much for joining in all the way. We're excited to have you on board. And then we have very erudite discussants in persons of Mrs. Diane Okoko, FCIArb. She is the principal partner of Marcus-Okoko and Co. Thank you so much for joining in, ma'am. And we have Mr. Osinachi Nwandem, FCIArb, is the senior associate of Aluko and Oyebode, all the way from Lagos. We are truly, truly thrilled to have you on board this webinar. And we look forward to all the very intellectual, intelligent, and brilliant contributions from the eminent discussant and lead speaker. I also recognize all the distinguished members of the EXCO, Chartered Institute of Arbitrators, Abuja Chapter, and members of the chapter as well. Ladies and gentlemen, once again, I welcome you on board this very auspicious occasion. It is indeed a very timely webinar that seeks to discuss, analyze, and talk about the challenges that engineering delays can pose in construction projects. So the theme of the webinar is engineering delays in construction contracts, analysis, damages, and legal remedies. And of course, we have very, very expert individuals on board who are going to be doing justice to this subject matter. And so very quickly, I'll state the ground rules of this webinar. We're going to start with a welcome remark by the Sector Interest Group Chair for 3 minutes, who is ably represented by the first Vice Chair, Mrs. Roslyn Wosu, FCIArb. And then we'll have the chapter goodwill message delivered by no other person than the chapter chair himself, Honorable Shola Ifeyin Oluwanuga, CARB, Chartered Arbitrator, for 2 minutes. And then we'll proceed to the branch goodwill message by the very eminent branch chairman, Chief Gola Akinola, SAN, Chartered Arbitrator, for 2 minutes. And then we'll have the abridged profile of the speaker and the discussants by my humble self for 3 minutes, and we'll proceed to the lead presentation by Mr. Aninda Mitra for 45 minutes. And after the presentation, we're going to have presentations from the two discussants for 10 minutes each. And then, of course, after the entire presentations, we'll have an interactive question and answer session for 20 minutes that will engage the full panel. And we'll proceed to the closing remarks by the chapter chair for 5 minutes. And finally, vote of thanks and closing by the chairman of the, or chairperson of the committee, the organizing committee of the construction webinar. So without further ado, I will proceed to humbly invite the chairman of the SIG, the Engineering, Construction and Real Estate Group, Engineer Oyebode, FCIArb, ONCFR, ably represented by Mrs. Roslyn Nwosu, who is the very eminent chairman of the planning committee of the Construction Law webinar. You're welcome, ma'am. Please make welcome Mrs. Roslyn Nwosu, FCIArb. Excited to have you.
Thank you very much, Sam. Thank you very much. Please permit me to adopt the already established protocol. On behalf of the chair of the Engineering, Construction and Real Estate Special Interest Group, I welcome of the Chartered Institute of Arbitrators, Nigeria, Abuja Chapter, I extend a warm welcome to each of you to our highly anticipated webinar on engineering delays in construction contracts, analysis, damages, and legal remedies. We are delighted to bring together esteemed professionals in legal industries to delve into one of the most critical aspects of construction projects, delays. This webinar aims to provide valuable insights into analyzing and addressing engineering delays while exploring the legal implications and available remedies. As chairperson of the Engineering, Construction and Real Estate Special Interest Group, I'm thrilled to witness this collaborative platform where knowledge, experience, and ideas will converge. The webinar will navigate the complexities of construction delays, examining the multifaceted challenges projects stakeholders face, and exploring effective resolution mechanisms. Our distinguished panel of speakers comprises of leading industry experts and legal practitioners with extensive experience in construction law and arbitration. They will share their expertise, best practices, and case studies, ensuring that each participant gains invaluable knowledge and practical takeaways to apply in their respective fields. I extend my heartfelt gratitude to all our esteemed speakers, participants, and the organizing team for their unwavering support and commitment to making this webinar a resounding success. I encourage all attendees to actively engage in the discussions, ask thought-provoking questions, and contribute to the collective growth of our community. We are confident that this webinar will serve as the catalyst for empowering professionals in the construction industry with the tools and legal insights to navigate engineering delays effectively. Once again, a warm welcome to each of you, and we look forward to an enriching and productive session. Thank you, Chairperson, Engineering, Construction and Real Estate Special Interest Group, Engineer Ebele Okeke, FCIArb, OONCFR. Thank you very much.
Wow, thank you so much, ma'am, for the beautiful welcome remark. I will have the privilege to call on our very own chapter chair, Honorable Shola Ephraim Oluwanuga, to deliver his speech for 2 minutes. Very coincidentally, I just discovered that I attended the same alma mater, Obafemi Awolowo University, with the distinguished, chapter chair, and it's such a privilege
Well, thank you, dear moderator. I have not prepared a speech.
Yes, sir.
And might be taking slightly above 2 minutes because the chairman of the branch has also asked me to stand in for him. So I'm wearing 2 caps in this one small head of mine. I'd like to acknowledge the presence of the past chairman of the Chartered Institute of Arbitrators, Mrs. Funke Adekoya, SAN, who is here with us. The first vice chairman, the current first vice chairman of the Chartered Institute of Arbitrators, Shola Adegbomire, Ciarb, and then of course, my first vice who has just spoken, Mrs. Roslyn Nwosu and our team. This seminar or webinar was crafted by the SIG group. The special interest group is the baby. Yes, it's the baby of the Abuja chapter, but without the help and support of the branch chair, it would not have come to be. And I'm very happy today because this, the Engineering, Construction and Real Estate Interest Group is indeed making us proud in the chapter. And the purpose of this program, of this webinar, is to further equip lawyers and other arbitral practitioners on the rudiments of construction law. And there's no better person than the speaker, Aninda Mitra, whom I spoke to about a few weeks ago. He was in Malaysia. And I said to him, wherever you are, you must make sure that you take this program for us. And he agreed. And one other commitment, which he has also given me, I would tell us at the end of this. Having said this, let me not say too much because there's a lot to say. And indeed, there's time to say it. So once again, I want to thank the SIG Special Interest Group, ably chaired by Engineer Mrs. Ebele Okeke, and then of course, the chairman of this program for today, the planning committee, Mrs. Roslyn Nwosu and our team. Thank you once again for the opportunity and all those who are attending this program. As at today, we had about 350 people registered for this program. And then I want to thank you because we've reached 100 on this program, aside from those who are on the YouTube. Thank you very much. I'm waiting. Thank you.
Wow, thank you so much, sir. Thank you so much, sir, for the wonderful goodwill message. We do appreciate you for joining in. And of course, by extension, we also appreciate the branch chair for extending his goodwill message to us through you, sir. We will proceed right away to introduce the lead speaker as well as discussants. This promises to be very succinct and very value-packed. So I'd like you to strap on your seatbelts as we take a deep dive into the presentation. But before we do that, I will have the opportunity and privilege to read to us the profile of each discussant as well as that of the lead speaker. So I'll start with the lead speaker, Mr. Aninda Mitra. Mr. Aninda Mitra brings 21 years of significant experience in contract management. He specializes in construction and engineering law. He specializes in engineering law issues as a techno-legal specialist. With a strong understanding of contract law engineering, he oversees the contract management process and ensures contracts meet legal and compliance requirements. And I'll move on over now to our first discussant for the day, Mrs. Diane FCIArb. She is a very knowledgeable and skilled corporate lawyer, arbitrator, and notary public. She is the principal partner of Marcus-Okoko and Co., an Abuja-based international corporate law firm. She is a fellow and an approved faculty member of the Chartered Institute of Arbitrators, UK, Nigerian branch. a fellow of the Institute of Construction Industry Arbitrators, and a member of the Institute of Directors. And then, of course, I'll read the profile, very short profile of Mr. Osinachi Nwandem, FCIArb. He's a senior associate of Aluko and Oyebode, and is a certified construction industry expert with extensive experience in construction law and arbitration. He is a fellow of the Institute of Construction Industry Arbitrators and is also a West African region editor of the African Construction Law SIG blog. He is currently a doctoral researcher at the Nnamdi Azikiwe University in Nigeria, where his research focuses on exploring viable remedies to multi-party and multi-contract disputes in the Nigerian construction industry. Ladies and gentlemen, please make welcome for the first time at Chartered Institute of Arbitrators, Abuja Chapter, the lead speaker of this powerful and value-packed webinar on construction law, Mr. Aninda Mitra, Senior Contract Specialist. I will turn over the webinar now to Mr. Aninda Mitra for his presentation for 45 minutes. Thank you very much and stay tuned. Mr. Aninda Mitra, over to you, sir.
Yep. Distinguished ladies and gentlemen, Chairman of the House, Mr. Moderator, Discussants. First, let me thank the organizers, Ciarb Abuja Chapter, for this webinar. Good afternoon, and thank you, audience. I think I'm audible perfectly well, right?
Perfectly audible, perfectly audible.
Okay. I'd like to first thank one of my teachers, Mr. Diane, who is not present in the current webinar and is an expert in delay analysis, for this inspiration on this subject, which I'm going to share with you, because many of his thoughts I'm going to share in this webinar. Mr. McLister is a British citizen. The time allotted for the speech is limited. I like to get straight to the point to make use most of the time. Any questions I will suggest, please write in the messages, to which I will start replying once I finish my speech. The chapter of ignoring delays in construction contracts, analysis, damages, and legal remedies can be spoken for hours and days, and there are numerous case laws around the common law world. However, due to limited period, we will discuss the salient features of this subject. Let me brief in a few sentences what modern construction law is about for the benefit of mixed audiences. Construction law is a blend of two subjects: an activity that initiates in construction and protected by law, ends in the hand of law if the dispute is adversarial. In the first part of the section, the technical audience will find many things obvious, and the lawyers shall find new ideas, while in the second part of the section, it will be reversed. And I'm definite at the end of the session, the entire audience can grasp in a singularity. Every construction contract has three essential elements: scope, time, and money. I will share the slide. Please bear with me. I repeat, every construction contract has three essential elements: scope, time, and money. One of the interesting features in the modern construction industry is the involvement of engineer, architect, and lawyer to supervise the project simultaneously with the project manager of the construction company. This is something very special, but in a lot of the world, this has taken up. Normally, the thing is that when there is a trouble, we call the lawyers, but that's not so. The new concept coming in construction industry is to have the lawyer and the project manager together right from the tender stage till the closeouts. One looks at the technical part, other looks at the legal part. This is a new concept and it's working really well. Today, we will be looking at the aspect of time versus the liability for delay and how that should be analyzed in the context of our construction or engineering contract. I will, in a Nigerian context, I would like to bring a feature over here. Many may think somehow that I may be exaggerating a bit. It's important to bear in mind in the context of any government-funded contracts where contract time is not much of a sense to the employers. This is true in every country. Some have more impact, some have less. And a sense due to the poor cash flow to the contractor. Albeit in the private sector, this is of paramount importance. Delay is probably the most discussed and debated and evergreen aspect of construction law that you will ever come across in the future. And that is because it frequently involves complex interconnected issues, but when taken together, test and stretch established contractual interpretation and the case laws, you shall find the subject fascinating and intellectually challenging. Whether you're a lawyer or a construction professional, you must have a conceptual understanding of this subject. This is to provide you with some insight of the challenges that it presents and who carries the liability in all two common aspects of the construction disputes. Now, what is delay? This is the presentation here. First, we need to conduct an objective assessment of the delays. Secondly, establish what is to be done by the terms of the contract. By when you get into the details of it, it's not always as simple and straightforward as that. The relationship between time and money is the paramount important one to consider, because in the construction industry, additional time inevitably means money. For a contract, the longer it takes, the project will cost both the parties, employer and the contractor. The longer before it benefits from its investment and stops, and it to return from it, the delivery of the contract is longer. Neither party wishes to carry the additional cost and the issues. You will agree to it. In a typical construction contract, the employer's route to recover the losses is through things being late, is through the damages. We always call it the liquidated ascertained damages. We'll not get involved much in this discussion this afternoon. For this contractors is to resolve the late completion of the contract, and it's typically through the clauses that deal with the changes, variations, and unforeseen risks. And for most contracts, there are two separate parts and have different rules, regulation, terms, and mechanisms. And extension of time does not on its own entitle a contractor to claim the costs, like losses and expense. This audience have to be very careful about it. There are certain kind of delays that can happen. Previously, it was called force majeure, but FIDIC 2017 has changed to exceptional events. In exceptional events, you don't get any cost, only the time extension is possible. And the only thing that an extension of time award does is to relieve the contractor from time-related or liquidated ascertained damages. Because the contractor has been given more time because of something that has happened, he's not going to be penalized. That's a part of the liquidated ascertained damages. So it's important to bear in mind that we are talking primarily about the extension of time to relieve the contractor from the liability of delayed damages for overrunning the completion date. I will now start explaining some of the slides one by one, and we'll be able to manifest the terms of the topic of this webinar this afternoon. Let's have a look at the Nigerian construction growth sector here. I put the URLs of the citations from where I have the data. As you can see, in a $488 billion 2023 GDP is going to be something close to 915 after 5 years. And this increase of GDP has also large contribution to the construction sector, which is now at 135 and likely to come close to $150 billion after 5 years. So you can imagine the impact of construction in Nigeria and how much involvement the construction lawyers have to be in a very short period of time. But there are certain shortages which I have felt in this country, which we need to work in a team to pull things together. Qualified construction lawyers to guide construction and resolve construction claims and disputes. It's not a matter of only having an arbitration. That's part of the last thing that we do to sort out. But as I said right from the onset, we need construction lawyers. And I will also share the similar opinion with the members of the construction industry in this case, where lawyers should be part of the team right from the onset of the contract. Secondly is Society of Construction Law. Now, many of us here among the audience have ideas about what is it actually. There are 4 previous Society of Construction Laws that I've listed over here: United Kingdom, India. We have the one in Canada, Australia. They are quite active, especially the one in UK. This particular media shall form, in my opinion, a backbone of spreading the news and enhancing this chapter in the coming future in the country. There exists really a construction law website, as I've seen, but I really couldn't get much document or paper or journals inside. And that's a premier thing what I have seen being a member of Society of Construction Law in the United Kingdom. I've observed a lot of exchange of thoughts, ideas, papers, what's the latest information, how the case laws are going on. Substantial information can be gathered from this. So this is something I'm going to come back later again about the Society of Construction Law and manifest the importance of it. Let's get on to the third part of it. Contractual delay and critical parts. Now, as far as critical part is concerned, let's have a wording here. When the contractual activities are incomplete, to comply with the scope of work and completion time under a contract, the contract is said to be under contractual delay. Some of the audience may have ideas about disruption, but let us not mix disruption and delay together. Disruption is not delaying. Disruption does not delay a contract. As far as the definition of what is critical path is concerned, this is really a technical term, I must admit. I have taken almost a primary citation from Keating on construction contract. I've cited it on the slide, you can have a look. Then on the 11th edition, chapter 8, section 4. I will not repeat what he has mentioned. All the audience can read it. And to the word, in my 30 years of career, I've followed it, and it works perfectly well to the word as is in the slide. We'll go to the next slide to discuss about one second. I'm having a bit of trouble. We'll talk about the types of critical delays. As we have a picture about what is a critical delay, we'll talk about the types of critical delays. It's well defined over here on the right side. What are the two types of critical delays? Non-excusable delays and excusable delays. It's well defined what are non-excusable delays and what are excusable delays. I will go to the next slide where I can explain better what is concurrent delay and dominant delay, rather than defining in a definition form. This is a standard baseline program of a very simple construction project. Ladies and gentlemen, who are in the legal chapter here of the legal business, please don't be afraid to see this kind of thing, because just it's being a bit technical. All of us have houses. Some of us have even built houses, although we are not, many of us are not engineers and have built houses. We have some of the items here concerning building items, which is very easy to understand. And the orange red line is the baseline program. That means you have a program which you have conceived at the beginning of the project. And program is the heart of any project. Without a program, you have no understanding of your duration, your cash flow, your resource mobilization, nothing. So you must always have a program. We have it for any little event we do in our life. So this is the baseline program. Let us not consider the green part now. Let's just concentrate on the orange and the red line at the bottom. That's the baseline. And it has a completion date, something close to 21.5 weeks, as you can see at the bottom, right at the bottom. Now let's see what happens to the baseline program when there are some delay events taking place during the course of the program. We are observing a pink line coming in, and this pink line, as mentioned on the left side of the program, is there's an instruction coming from the employer or the architect or the engineer that I'm going to change the doors and the windows. Now, the contractor has already procured the doors and windows or in the verge of procuring it, but it has created certain hindrance on the program, the baseline program, which is, you can understand by our common sense. So the pink line disturbs the program at the middle. When the pink line comes in the middle, we can see now we will go back to the green lines. The green lines were fine at the beginning before the pink, but now the green lines are getting disturbed. The green lines is actually what is getting executed. So we foresee, or maybe you can also say that end of the project, we have found out that all the green lines have shifted to the right. Not all of them, many of them have shifted to the right side. Means there are certain delays that have taken place, and the reason for the delay is the pink line, which has been created by the employer. I think up to here, it shouldn't be a problem. So we have delay in completion, which is shown by an arrow right at the bottom. Now we go to the next slide to check the, I will jump a slide more and come back to the previous slide later. We'll come to concurrent delay here. We will observe a second pink line entering the scenario, and the second pink line is late provision of utility supplies. Now, utilities normally, let's say you have the pipes in the house to fix, electrical fittings, whatever, and this is the responsibility of the contractor. Now there are coming certain delays in the supply, and this is attributable to the contractor, unlike the previous pink line, which was attributable to the employer. And these two pink lines are running parallelly. To some extent, it starts from week number 5.5, let's say, and up till week number 18.5, you see the pink lines are common. So they are occurring concurrently together in the program or the life of the project. These two delays, one where the employer is culpable and the other one where the contractor is culpable, are occurring concurrently. And that's the concurrent part of the delay. We can't figure out from here which one is dominating. We can't figure out. But they are concurrent in nature. So the employer cannot blame the contractor, while the contractor cannot blame the employer because they are occurring concurrently. At the end of the contract, when you go retrospectively back, and we will find these two are occurring concurrently. And again, we have a little bit of pink line on the bottom projecting outside. That's where the contractor is culpable. It's beyond 18.5 weeks, employing up to 21, close to 21 weeks. So this 2.5 weeks is an excess delay, and an employer will always say, Mr. Contractor, this is where you are culpable for it, and that's true. So overall, these two delays, one occurring concurrently and the other occurring in addition, have created the project over very close to 23 weeks for the contract to complete. We have a dominant delay here. And that dominant delay is the delay of 2.5 weeks between week 18.5 to 21. That's a dominant delay. We will go to certain case laws to find out. And when we'll go to the claim management, we'll have to explain and demonstrate that what is the concurrent delay and what is the dominant delay in this particular project. We'll go back to one slide, which we didn't discuss, requirement of parties. These are standard requirement of parties. Some contract can have more, some contract can have less. But these are responsibilities, or in legal terms, you can say the obligations of individual parties. In most of the cases, we have seen that there are lapses in one event or the other by any of the parties. And that is one of the major reasons why there are delays in construction contracts. Now, this is not an exhaustive list. This is just a general obligation list from a standard contract practice. Now, this analysis, what was shown in the previous slides, is a very, very simple analysis. In large contracts, large construction projects, you can have quite a complex analysis. Now, in none of the contracts that I have observed, it is mentioned which kind of analysis we will follow. I've listed 6 mostly follow delay analysis on the right side. You can understand from the English language or the wording of the analysis, and I will explain a bit. It's planned and as built. So you have planned the project, and once you complete the project, you have an as built situation. You retrospectively go back from your records and make the analysis, and you find out what's the delay level and who has delayed more or who has delayed less. That's first. Then you have the impacted as planned impact, how much impact has come on the project on the delay, and what was planned. Perhaps as built, This is also another kind of delay analysis, but I will not make the matter too complex for audiences who have not much knowledge about the delay analysis. I will try to explain in a different way. On the left side, you can see I mentioned about Society of Construction Law again, which I was mentioning before. Society of Construction Law has a protocol. I would say this forms one of the basic guidelines for construction lawyers to understand delay and disruption. One of the slides down below, which perhaps is not with the audience, but I will just give a screenshot for all of you to see. This is the foundational support of delay analysis. All I'm talking today, and most of the experts all over the world are following this. Ladies and gentlemen, kindly take a note of what is mentioned here. This is available in the public domain. It's 84 pages of PDF. And I will advise all the audience to go through this protocol. It's an exhaustive demonstration of delay and disruption with legal backups. This is the most important part of delay analysis. So as we are discussing about the delay analysis, I will shift back. This is 2017 version. This is the second version of the Society of Construction Law Protocol. I will go back to the previous one again. All these 6 different types of delay analysis, what we can see on the right side, are being well explained in the protocol. And since we have a very limited time, I won't be able to go inside detail to explain all of them. Now, many may think how we do this analysis. In today's world of technology, we have a lot of softwares. Originally, Microsoft Project is the one where we could do all this. Now, with the time, we have Primavera versions also, where we have also the legal inputs and support from Primavera P6 version. This is mainly done by planners and schedulers who are in construction. So this part is not really expected from core lawyers unless you really show interest in this chapter and learn this one, but it's not that difficult, that I must tell you. But in the end, this analysis is brought out to an arbitrator or to a judge in a court. You may think that which one is the best method. As I mentioned, law accepts the logical case, one with the common sense and specific to the case. This comes to the practice of time. The best method might not be the most accurate, but the one which gives answers to the most readily understood and acceptable to the tribunal. So when a tribunal is formed with arbitrators and lawyers, they have to also have a clear grasp about the different kind of this analysis, well explained in the protocol. And there are also certain books which demonstrate this analysis. But the protocol is the basic thing, I insist. We will go back now to, I think, we'll go to more interesting cases now about the claim management part. This one, most of all your friends are quite acquainted to this matter, claim management. Before we go to claim management, I have to talk a little bit about the principle on which the common law stands on this issue of delay analysis. Causation. Causation, potency, cause and effect. Law looks for the cause. I will just give a little example of it. Suppose a project is going very well. There's no problem with any kind of delay. All of a sudden, the client brings a certain variation in the project. most of the contractors will jump up and say, we need additional time. No, a very simple no from the judge or from the arbitrator should come, because if it can be proved that this additional work can be done within the same time without any delay, the contractor will never be entitled for any kind of additional time. Whatever delay analysis he can prepare, the logic will govern. That's for granted. So causation is the key, and the potential on which the delay has occurred is extremely important. And then the effect of such a cause. So these are the certain things need to be demonstrated in the claim management. While we talk about the claim management, I have to go back to certain area of what is claim. In my career of almost 30 years, I have not found any really primary citations where claim is defined. Most of the contracts, whether it's bespokes or standard form, they do not define what is claim. And that forms a big issue when a party is claiming something in a court of law or to the arbitrator on claim through a claim management. The first time what claim has been defined is in 2017 FIDIC. This is on the definition of 2017 FIDIC. All of you audience can have a look later on in 2017 FIDIC, where FIDIC defines what is a claim. Unless this is defined, the claim management will not have sufficient foundation. Claim means a request or assertion by one party to the other party for entitlement or relief under any clause of the contract conditions, or otherwise in connection with or arising out of the contract or the execution of the works. I have read the definition from 2017 FIDIC. FIDIC never defined in the older versions of 99 or 87. JCT doesn't have ADC, the latest one with the collaboration new engineering contract also does not define what is a claim. And most of the bespoke contracts I have not seen what is claim, how is claim defined. So in the claim management, we will broadly classify out the details, how the claim should be submitted when a party is suffering a delay, for example. We have the steps to file an effective legal claim. First, we have an introduction. Then we have the cause and effect of the delay. Then we have an entitlement under the contract. Then we have appropriate delay analysis and logic. So in some of the cases, we may need to do 3 to 4 different delay analysis to make sure that which one will be accepted by the tribunal, either in an arbitration or in the court. Proof of mitigation of delay. This is immensely important under common law. As we know, all the law, our legal experts here, if a party cannot show that he has tried to mitigate the delay, he won't be able to get any remedy. Effect of the delay on the injured party. Then there must be some quantum analysis of what kind of cost you are talking about. I will not go to much detail because this will take a lot of time if we are talking about prolongation costs or let's say there are certain formula we use to guide us about how we do the prolongation, loss and expenses and all this kind of thing. But certain quantum analysis is necessary, which need a broader session to discuss about. And then coming similar case laws. So similar case laws, we will talk a little bit as time is going to run short very soon. I will discuss about one of the premier case laws in English contract. It's persuasive in other common law countries, but this forms the benchmark of delay case law. This is Oyebode and Chestermont. The entire judgment is available in the public domain. Interested audience can always have a look. the major issue here, I'm not going to discuss much about the case judgment and case laws. You can see the main principle here is coming back is the causation. Again, I insist on it. The causation is the main area where Judge Coleman has emphasized. This particular case law is very, very important for most of the common law countries. Now, in parallel to this particular case law of Oyebode and Chesterman, we have also observed a similar kind of case law coming up is City and Shepherd. This is also a British case law, but it happened in Scotland. There's a lot of debate on the case laws. Legal audience, I will request you to go through the case judgment. You'll find it very, very interesting. And when you sit on the chair of an arbitrator or on the chair of the judge, you may think twice about the issue of apportionment. English case law did not apportion, but the Scottish case law has apportioned. As it's mentioned at the bottom of the case law, is the principle is also found to be found in other jurisdictions. It is controversial and continues to generate much debate in legal circles. The idea of apportionment does not diminish the legal requirement to properly demonstrate cause and effect. That's a major reason I have put up the case law. The cause and effect is the key area. Whether you share the remedy between two parties or you have the remedy to single party is up to your judgment. But the cause and effect and the causation is a principal idea for these two case laws. So I would like to after this, I would like to stop on this session, and what I will mention here is if audience find this kind of demonstration very interesting, we can also propose for an upcoming webinar, and that's a boilerplate topic of construction contracts termination. Drafting, notification, suspension. Unfortunately, most of the contracts do not provide fitting guests, and it's very useful. Why? We can talk on it. And we have the common law in termination. It's very, very important. And the kind of breaches like repudiatory breach and contract law. And we can speak about the case laws. This is my proposal to the organizing group for the future, if our audience find it interesting. That's all for this afternoon from my side. Thank you very much, audience, for listening. And I hand it back to our moderator. Thank you.
Wow, thank you so much, Mr. Mitra. That was simply profound, detailed and comprehensive analysis of engineering delays that characterize construction disputes. Thank you for enlightening us on the different kinds of delays, the excusable delays, the non-excusable delays. And I just learned from you that disruption doesn't constitute delay. I honestly used to think that it did, but thank you for shedding a lot of light and, bringing perspective to what construction law entails as regards engineering delays. And of course, with regard to proposed webinars that we may have subsequent to this by way of follow-up, I believe that the Chartered Institute of Arbitrators has noted that, and we look forward to taking this conversation further for clarity and for more insight. Thank you so much once again, Mr. Mitra, for doing justice to the concept of engineering delays. I believe that if people have questions, you may please drop your questions in the chat, When it's time to take questions, we're going to allow the panel to take your questions. And if you also would like to ask your question live, you can also use the reaction button when it's time to ask questions so that we could call on you to ask your live question. All right, so without further ado, I will Mrs. Diane Okoko, FCIArb. She is the founder and principal partner of Marcus-Okoko and Co. In her presentation, she's going to be concentrating on the FIDIC suites of contracts with particular emphasis on clauses 8 and 20. She's also going to build on some of the insights that Mr. Mitra had shared about claim management. She will be speaking about the steps towards building the claim and what the tribunal would be looking to see in order to establish such a claim. So she's going to be speaking from the perspective of an arbitrator. Ladies and gentlemen, please make welcome the very delectable and erudite Mrs. Diane Okoko, FCIArb. I'll turn over the webinar to you now, ma'am.
Thank you, Samuel, and good afternoon, everyone.
Good afternoon, ma'am.
Gratitude to the organizers, the Chartered Institute of Arbitrators, Abuja Chapter. That's my chapter, by the way. And especially to the organizing committee of this webinar. So I've got 10 minutes and I've been warned by Samuel to keep strictly within 10 minutes. But Aninda has done a very, very comprehensive presentation. So what I'd like to do at this point is tilt the audience in the direction of, understanding certain elements of delays, looking at the types, the remedies available to the parties, within the contract, and what, if any, the remedies would be, whether legal or contractual, and who bears what. So I will be very fast. I'll skip over everything Samuel said. I will concentrate on the FIDIC suites. My slides show you the advantages of using the FIDIC suites, right? So let's just breeze over certain things. I've talked about the golden principles of the suites. I've talked about who the role players are within those contracts, right? And to clause 8 of that suite, which is really about the commencement, delays, and suspension, right? So these three elements, these three subjects are subsumed within clause 8, but broken down into certain sub-clauses. As soon as you take a look at that book, it helps you arrange your contract, and it's very easy for the flow. If you recall, Aninda spoke about, the categories of delays in construction, the excusable delays, compensable delays, concurrent delays, non-excusable delays. I do take it for granted that the audience can see my slides. Samuel, could you please confirm?
Absolutely, ma'am. Very visible.
Yes, we can.
We can see your slide.
Thank you. So non-excusable delays, employer-induced delays, contractor-induced delays, unforeseeable site delays, right? All of these are where the contractor fails to complete their works within the time, right? So the delays shall be deducted. And the reason I'm saying this is because at the point where damages are due, damages to the employer at this point is contained within the percentage rates that the appendix to tender has already indicated. Okay, so this is like a statutory, not a contractual, rather a contractual agreement between the parties, because they have agreed to use the FIDIC forms of contract. Then we realize that delays caused by the contractor this time and compensable to the employer have a percentage of deduction within the appendix to tender. Okay, and sometimes you find that, so this tells you that damages would be an almost automatic, the reason I say almost automatic compensation to the employer is because these have to be established at some rates within the percentage agreed before the employer can get. So in summary, and I'm going to go down, it looks like delay damages for the employer, which is payable by the contractor, okay, it would be a percentage of the contract sum as agreed with the work, and then other times termination, but termination as I go down. So I did tell you that I was going to concentrate more on the claims. I imagine that most of the participants in the room are arbitrator, and unfortunately, I have 10 minutes. I think I can begin now to say I need, but I can be bold to say. Clause 20 speaks about the submission to claims, dispute resolution. And when I'm talking about this, I actually am referring to the red and yellow FIDIC books, right? So that our audience don't get confused. In my slides, you would see how I have divided the clauses to which speaks to what. Now, claims are usually of two types. The contractor may assert two kinds of claims. The first would be the legal claims. These are claims which the contractor may be entitled to assert under the law governing the contracts, right? And then the second would be the contractual claims which the contractor can assert by virtue of specific provisions within the contract. So in bringing a claim, first and foremost, when the event for which the claim is being asserted upon has happened, the contractor has 28 days within which to make a notice known after the occurrence of that event. Now, this is crucial because it's a time-barring notice. That means that as soon as this happens, and the contractor exceeds their 28 days, they have lapsed in that, and it no longer accrues to them. Within that time, all they're bringing is a notice. As soon as that notice is given, 42 days within, they can bring the full suit of what this claim should look like, the details constituting this claim. Right? And this is not a time-barring notice because they can keep collect claims. Okay. Now it is the contractor's it is in the contractor's interest to make contractual claims. My emphasis here would be to draw how the steps in dispute resolution within construction industry claims come. So first and foremost, you would have your claim being made known to the engineer, right? So under the FIDIC suits, you're mandated to send that claim first to the engineer. The engineer at this point would do some sort of determination of that claim between the contractor and the employer. But the proviso here is the engineer is unable to evaluate legal claims, just contractual claims, right? And the clauses are very clear as to why. And the form of how this goes, and if there is an excuse or if there is a reason why the contractor is seeking an extension of time, which is one of the legal remedies available. Also, say where there are delays caused by authorities, but this is another conversation entirely. Then the contractor will be entitled to the remedy of an extension of time rather than another kind of remedy. So the way to bring all of that is contained in the subclauses. Now, the contractor should submit a fully particularized claim after the 42 days to the engineer. Remember, the engineer is to respond in principle within 42 days. Now, that response is actually a determination of that suit. A determination of that dispute, supposedly. And where both parties are in agreement and they're happy and satisfied with the engineer's determination, then they will go ahead with the contract. In the event that, there is an interim and maybe payment certificates issued and payments are made and stuff like that. However, where there is a dissatisfied party, that party would now refer that claim or that dispute to a DAB. This is the Dispute Adjudication Board. FIDIC tells you that every construction contract should have a standing DAB. Now there is the DAB, there is the DAAB, which is the Dispute Avoidance and Adjudication Board. Yeah. Some say that a standing DAB would cut costs when it comes to dispute resolution because they would have already seen this dispute, brewing, and they would avoid it if possible. That way, you do not descend into proper and full-blown dispute resolution. Others say it inflates the cost of the contracts or the cost of the construction because you have a standing DAB who may or may not have any dispute referred to them to resolve at any point, and who bears the cost. The cost is subsumed within the contracts. So I'm going to give you an idea of how this would look timeline-wise, right? So the occurrence of the event happens. You've got 28 days within which to send a notice, the notice of the intention to claim. This is sent to the engineer, remember. And then there is the 42-day window within which the contractor will put together the particular determination, where the both parties or the employer is satisfied, he will make a payment. If not, then there is resort to the DAB. So now let's look at the DAB procedure. A DAB, upon having this dispute referred to them, will have 84 days within which to make a reasoned decision. A reasoned decision is one where it's like an award, right? So every rationale for what is, the decision being taken is going to be included in it's going to be included within the determination made by the DAB. And then we go through the same process again, timeline here. The timeline here is 28 days after the decision of the DAB for a dissatisfied party to bring a notice of arbitration. Because so we've got the engineer deciding first, then the DAB does its own determination, and any dissatisfied party now has the opportunity to refer to arbitration. After 28 days, there is a 56-day window within which another level of amicable settlement can be explored. Where that does not full-blown arbitration, ICC is referred to under the ICC rules. The ICC administers the arbitration. So I'm going to skip over this very, very quickly and go to, good, so we've talked about the, I want to go straight into arbitration. And remember I said I will tell you what to look at, what the arbitral tribunal will be looking out for when an arbitration is referred to them under the FIDIC suite of contracts. First and foremost, improving delay, right? Documentation is very key. So by way of digressing, what documentation are we looking to see? I just concluded an arbitration last month, June, where it was very, very clear from the onset, the very second week of that construction contract, that there was going to be a delay. And how is delay measured? It's measured against the program for the construction. When Aninda was taking you through those graphs, you would see it was the graphs where the program that had been set out for that particular construction. So everything is measured against the program. Then, you know, at week 1, this is where we should be at the end of week 2. Notices are very, very important at this point, because where there are no notices to say we're falling short, then it is difficult to prove that there was actually a delay against the program and the delays are claimable. From that particular arbitration, it was very clear from the very second week. And the employer took their time to document every single issue that they felt was causing the delay and what they had seen during site inspection. So it was easy for me to see very clearly where the delay started, the steps that should have been taken to mitigate that were not taken, at what point, you know, the suspension should have come before even the termination, you know. So this is what the tribunal would want to see. Documentation, for instance, documenting the project schedule, right? Identifying the critical path. Aninda spoke about the CPM, right? So the critical path methodology, right? So identify it. How does it relate with what the impact on that particular project would be? By the time you identify this critical path, it's very easy to draw some sort of, a nexus between what caused the delay and how it impacted upon the project, right? So record. There's no overemphasizing recording. Aninda has talked about establishing causation, so I won't go over it again. Now, demonstrating notices, last month's arbitration, notice went out almost every single week, you know, evaluating concurrent delays. Aninda has spoken about it, so I will not talk about it. Now, this is a chart that shows you what the daily activity would look like, the record. So ideally, for every construction project, right, there would be it's called a site diary. So there are recordings of the happenings on a daily basis, documents for you to look at and examine. Even if you took a look at this document resolution process during the arbitration process, it gives you a lot of insights as to, you know, how this project went, and it's easier to do a determination. So I hear that I have 2 minutes, and I can proudly say that I worked within the 10 minutes. Please, nobody should talk about my calculating of time at this point, because we're not in a delays claim dispute. Thank you.
Wow, thank you so much, ma'am. That was simply profound. The insights you shared are very sterling and outstanding. Thank you so much for pouring out all the value that we could get within the time. I learned a lot, particularly with regard to what the tribunal will be looking out for. Documentation, you said, is one of the significant elements that the tribunal wants to see. They want to see the critical path, the program schedule for the construction project. They want to evaluate concurrent delays. And then, of course, keeping a daily diary that shows the progressive, you know, processes that are being undergone on the project. So thank you so much for shedding light. We can't wait to feed on the slides, if you will permit. We look forward to it because a lot of people are already requesting the slides. Thank you so much, ma'am. I know that some of us may have questions for Mrs. Okoko. If you do have questions, kindly take note of your questions. Very soon, we're going to get into the interactive Q&A, where you can have the opportunity of coming up live to ask your question. So when we get to that point, we'll ask you to use the reaction button, and then of course we'll take your question. If you'd like to write or type your question, you could type it in the chat box, and then we'll read it at the time. So, but it's not yet time for interactive Q&A. When the time comes, we are going to take your question. Thank you very much. We will proceed to the second discussant very quickly. The second discussant is a senior associate of Aluko and Oyebode. I had introduced him earlier. He is going to be presenting from the angle of counsel in arbitration, in construction arbitration. His presentation is going to revolve around the approach to assessing delay claims in live construction projects and claims preparations. You know, he has acted as counsel in several construction arbitration in the past, and I have the singular privilege and honor to bring up no other person than Mr. Osinachi Nwandem, FCIArb, Senior Associate of Aluko and Oyebode. Mr. Nwandem, I'll turn over the webinar to you now.
Yeah,
please make welcome, Mr. Nwandem.
Thank you very much. Thank you very much, Samuel. I don't know if you can hear me. Can you hear me?
Perfectly well. You're audible, sir.
Oh, thank you very much. I think it's a wonderful opportunity to be the last speaker. Yeah, good to see you too. So you get to have lots of expos. Yeah, but basically, my presentation will be a fusion of what Mitra and Madam Diane has said. And so what I'm going to be doing, I'm going to be discussing, and I'm going to be fleshing in true war stories, experience, managing, offering legal support to live construction projects. So I am opportune to work in a law firm that exposes, that gives me the opportunity to work with clients, midwife clients through their construction projects. I don't know if you can see my screen.
It's coming up, but I can see it. I can see that you're sharing your screen now. Oh, yes, it's up now. I can see your screen.
All right, so what I said, so just as a background, I'm going to just share my practical experience of fusing the law, the contract into live construction projects, and how we've been able to help parties, the employers, to manage construction delays, and have also been able to help them in terms of the arbitration processes. So basically, the speakers have done justice to certain things. So I'm just going to run, and I'm going to be very practical so that we get the meat from the webinar. Basically, there are implications to construction delays as the speakers have stated. And an employer sets out to construct, and the time is fixed in a construction contract. And what that time simply means is that at the end of this time, I should be able to take possession of the work, the finished work, and it must be done in line with the time we have agreed. But what we see in construction projects, and is actually not unusual, we see construction delays either owing to acts of the contractor, or we also see construction delays caused by the employer. So one very common one is variation. An employer may say, an employer in this case will be the project owner. He may say, okay, I want additional works. I want to tweak my designs. And as a result of tweaking those designs, the contractor, the project, is extended. There's an additional time to the project. But what the law does, by virtue of a principle called prevention principle, the law protects the contractor. The law wouldn't want a situation where delays are caused by the action of the employer. The law wouldn't want the contractor to suffer as a result of that. And so the law has introduced a mechanism called the extension of time mechanism, which gives the contractor and gives the contract, extends the life of the project because of the acts of the employer. And so that's why you find that most construction contracts will have an extension of time. Now, the disadvantage of not having an extension of time clause in the contract is that time is set at large, based on the prevention principle I have said. So the law tries to protect the contractor. But basically, the standard and basic principle of delays is if a project is not achieved within the time frame, then the culpable party will be the contractor. And the clauses in the contract have provided for liquidated damages, where the employer is entitled to certain amounts that are agreed by the parties. So basically, whether is a delay in a construction dispute, I think the first recourse will be your contract, will be the contract. And I've been opportune to work with the FIDIC construction contracts, and been able to guide parties through projects and arbitrations around that. And basically, the starting point is the construction contract. So your entitlement as to extension of time and liquidated damage, you find them, you get the first reference is in your construction contract. So either as a counsel to a party, as an arbitrator, the first point of call is the contract. What does the contract say about this delay? Who is entitled based on this delay event? Now, the beautiful thing about construction law is that we're able to, so where the contractor incurs delays, the contractor has an opportunity to seek for extension of time from the contract administrator. In FIDIC, it's called the engineer. So the contractor notifies the engineer. Madam Diane has been able to explain the process under FIDIC. So on the practical note, the contractor notifies the engineer, and informs him of that delay. The essence of that is basically to ensure that he gets the extended time and the engineer is able to assess. So basically what the engineer wants to see is that he wants to see that there is a delay event has occurred. Now, when he sees that the delay event occurs, he wants to see that the delay event was not caused by the contractor. And he also wants to see that as a result of the delay, the project, it affected the completion dates. So the project basically will not be completed at the contractual agreed time. So these are the basic standard requirements for a contractor seeking an extension of time. And to a large extent, the employer. So I'm going to run through my experience, merging the provisions of the FIDIC books and also live construction experience. I'm going to share with you, as we discuss, I'm going to share with you war stories discussing basically how we've been able to work with clients around the issues of delays, delay notices. It's very interesting. So I implore you to just join me. So there are 4 questions based on experience. I call it the contractor's quadrant approach. I call it that because there are 4 questions. So I have sat with the employer. So my team, we sat with the employer to look at extension of time requests by contractors. And we've been able to ask ourselves 4 questions based on the extension of time request. And that has motivated me to guide contractors on 4 questions they need to ask themselves before they decide if they are going on with their application or request for extensions of time. And we see this a lot through our application by the contractors. Basically, the first question that every contractor needs to ask themselves is this delay excusable? And if yes, what is my entitlement as a contractor under the contract? Lady Diane has been able to narrate under clause 8 of the FIDIC book, specifically clause 8.4, which enables or which necessitates or invokes the contractor's entitlement to an extension of time. Now, basically, the first question a contractor should ask himself is, this event, is it anticipated? Has it been provided for in the contract? Now, clause 8. Subclause 8.4 of the FIDIC book. So I'm going to be referring mostly to the FIDIC book because I deal a lot with the FIDIC books in live construction projects and in construction arbitration. So what is the delay event? And what are my entitlements? So we had a situation where a contractor comes in and says, due to the Naira redesign policy by the federal government, he's unable to, he suffered shortage of staff. And very uniquely in the construction industry in Nigeria, most of the staff are paid cash. So as a result of that, the issues with liquidity, he couldn't pay staff. So as a result of that, he suffered delays. And so he requested for extension of time and cost. Now, it was a FIDIC yellow book. And the simple thing we did was, we looked at the FIDIC yellow book. Clause 8.5 talks about delays by authorities. First, he's passed the test that is a delay event. Secondly, what are his entitlements? Is he entitled to costs? And the answer is no, he's entitled to only an extension of time. So as a contractor, you would want to look at your contracts because basically these principles are what the arbitral tribunal will look for if you are dissatisfied with the assessment of the engineer. So those are the things you look. The secondness, and very critical, and all the speakers have been able to dwell on it, and I'm just going to rush through it. The second question the contractor should ask himself is the delay critical or non-critical? So the principle is very clear. Irrespective of the delay, it must affect the completion time. And the critical part, I'm going to run through an analysis. I'm a lawyer, so but I try to play with ideas around, based on our experience, ideas around, that if you look at what we've been able to, what I've put up on the screen, it's going to guide us on a critical path. Now, a project is going on and the employer has certain activities that leads us to construction, maybe piling, foundation, decoration, and the like, and he has listed them in activities. So if you look at this, what we have here, it's a 170 days project. Now, you see that for A, it takes 0 to 4 days. And immediately after that, the activity on B starts at day 4 to 44, and the activity for D starts at day 44. So a critical part is a part that it's a sequence of events where there is no leeway, where there is no slack. Now, if you look at A to B, there's no slack. And so if a contractor suffers, maybe for A, he goes beyond the 4 days stated, he goes to 5 days, 6 days, that means it's affecting work on project B. And so there is going to be a delay that will trickle down to H. Now, if you look at from A to C, you see that between A to C, we have a float of or a space of 20 days. Now, we also, if you look from E to G, we have a float of 8 days. Now, what does that say? Now, there are a sequence of events, but in between there's a slack, and that's the float. Now, what does that mean? It means that if, for instance, in E, we have 8 days in between, and he has to work from day 61 to 101, he suffers delay 4 days. He can always move in the stack and in the float. And so we can see that the red is a critical delay, and the blue is not a critical delay. And we see life concerns like that. In a very interesting case, in a UK case, Glenian Construction Limited, the contractor had in his program to construct, it was a 114 weeks project from the program, but he set at 101 weeks. What happened was that the project suffered a number of days beyond his own set time, and he sought to seek extension of time. And the court said, look, the most important thing is, did it affect the contractual completion date? And since it didn't, that means it was not on the critical part. So those are very important questions we need. Now, the next one is for the contractor, which is very keen, is ask yourself this question. Am I required in the contract to comply with my notice requirements? And so back to my redesign policy, so design story. So he says, due to the redesign policies, he suffered shortage of staff. And what we were able to pick in from one is that, yes, it was an entitlement he had as a result of the government policies of the government authority. But this issue of redesign ended sometime in March, and he's coming up with an extension of time request in June. The provisions of FIDIC 20/1 says that the contractor has 28 days from the day he's aware of the event to notify, else he loses his entitlement. So that was a flat no for him. It was a flat no, and he couldn't get that. In a very interesting case, there's this Australian Development Corporation case. The contract provided for 30 days notice. Now, the contractor did not provide or issue any notice within 30 days. His extension of time request was rejected. He went to court, it was still rejected. So these are questions the contractor should ask himself, because these are the questions that the employer will look at. Now, most importantly, and it has been felt and it cannot be overemphasized, the issues of contemporaneous documents. Now, M.W. Hamson, he's an author of International Construction Contracts and the ICE. He made a very remarkable statement. He said, a party to a dispute, particularly if there is arbitration, will learn 3 crucial lessons, but often late: the importance of records, the importance of records, the importance of records. He emphasizes 3 times. Why? Records are very important, not just records, contemporaneous records. If you look at the FIDIC books, especially subclause 20.1 says the contractor substantiates his claims and provides claim. What are the particulars? They are contemporaneous records. They are photographs, minutes, side diaries, emails, worksheets, timesheets. Now, the essence of this is basically to enable the engineer or to enable the contract administrator properly assess, and if he finds credible, award, extend the time or award cost as the case may be. And interestingly, this is what goes on to arbitration. So what the engineer does is also what the arbitral tribunal will do. The arbitral tribunal will look at if you have contemporaneous evidence to support your document. I think towards the end, I'm going to just run quickly so that towards the end, I'm going to share a case that is going to inform you. So back to my redesign story. So the contractor sends us a notice and informs us of the redesign, but it's just a letter. And by the contract binding us, the contractor cannot enjoy or be entitled to an extension of time. Because what is required from him, if he's saying it's a redesign policy, I need to see your side diary. I want to be able to look at your side diary before the redesign policy and look at how many personnel were on site and the level of work you've been able to do. And I want to look at your side diary after, during the redesign policy and see the number of staff on ground and the work done. And that way I'm able to understand your complaint. I'm able to understand your story. I'm able to pick the number of days you suffered this. So if this is not available, it's not a sentimental thing. The contract says he's not entitled to an extension of time. Now we flip over to the other side of the employer. We look at the employer's quadrant approach. So I decide to wear a hat of the employer. So we also have a live issue we are working on, and the employer has to make claims as a result of the contractor's obvious non-excusable delays. So what are the 4 things that we consider? Number 1, is the delay a non-excusable delay? Remember the prevention principle I discussed. The law will want to protect a contractor where the cause of the delay is as a result of the employer. So we look at this. In this delay, did we have anything to do with that? Did we at any point cause the contractor to suffer the delay? And if the answer is no, basically, the most important thing is that the contractor will pay liquidated damages. Now, if you look at what I have on my screen, subclause 8.7 of the FIDIC Yellow Book, you're going to basically see that it's a delay claims, it's a delay damages, which is liquidated damages. And it says basically where the contractor fails to comply, that is fails to complete within the time, he shall pay liquidated damage. Now, liquidated damage shall be stated in the sum stated in the appendix to the tender. Now, in construction contracts, we have what we call the appendix, or we have the contract data. Now, the contract data states the basic information that you may not see in the general conditions, one of which is the time for completion. Now, you will see time for completion, 365 days. You see time for completion maybe 15 months, depending, or 12 months, depending on how the party will go. But if he fails to complete with that time, he's going to pay liquidated damages. And the liquidated damages is also stated in the contract data. Now, you see liquidated damages of 1 million naira per day, $3,000 per day. Now, the essence of that is a form of, is to incentivize the contractor to proceed with the work. And is also to protect the employer, to ensure that, the employer, because basically, and from a commercial point of view, we set out for construction, not basically to have a dispute. Dispute is when it's a last resort. So basically our intentions, the intentions of the employer is to use the project, maybe a real estate, and he wants to, let's use an example, an off-plan arrangement, and he has investors that are waiting to take on this at a particular time he has agreed. And he has a sunset clause in his agreement, in his contract of sale agreement. And that clause, he doesn't want it triggered. So he factors the worst case scenario in the event is triggered. How much is he going to lose? Those things are, negotiated in the liquidated damages provision. So we want to find out. Now, the quadrant 2 is, am I required to comply with any contractual requirements? Now, you may say no, but from the FIDIC point of view, the employer by sub clause 2.5 has a responsibility, an obligation to notify of his intention. There's a very interesting case, NH International Limited and National Insurance. So the employer decided to just start deducting liquidated damages from the payment application. And the court said, no, he was going through the back door. That the most important thing he was supposed to do by the rule, by the contract, was to issue a notice, of his intention to deduct by 2.5. Having failed that, he had shut the front door. He couldn't go through the back door. Are we done?
We're enjoying your presentation, but time is actually
okay.
up.
All right, let me just quickly run up to. So on the issue, so I'm going to just take 2 minutes. So on the issue of, so I'm just going to jump to the 4th quadrant, the importance of records. Now, basically, I'm just going to emphasize what I'm going to emphasize. The arbitral tribunals prefer delay analysis that follow the pyramid model. If you get to arbitration and you want to make a delay analysis, the first thing that the tribunal looks at is it based on the contemporaneous record? Now, the contemporaneous record is the most important. It tells the story. And we go to the witness report, the evidence, because they now help to interpret the contemporaneous records. The expert reports now help to work with the witness report and the contemporaneous record to produce that. And we see that in cases in white construction, where it was a very messy scenario where we had both experts giving scientific definition, and the court wasn't pleased with that. And so it's very important. Contemporaneous records are very important. And for anybody seeking extensions of time or liquidated damages, please take time to ask yourself these questions before you proceed to request, and even before you proceed to arbitration. So I'm sorry I jumped into the time. Thank you very much.
Thank you so much, sir, for that very comprehensive presentation. We enjoyed your presentation, and it was very detailed. We do appreciate the time spent and the creative industry that has been deployed into your presentation. So we would proceed now to take questions. If you have questions for any of the panelists, we'll be excited to take your question now. We have very limited time to take questions, so I'd like you to kindly use the reaction button if you would like to ask your question, so that questions do not stem out of questions. So we'd just like to know the number of persons who would like to ask questions, and then we will open the floor for the interactive Q&A. So any question, please? And we'll also appreciate if you could state the person to whom your question is addressed.
May I ask?
I saw a hand earlier.
I think most of the questions
May I ask?
are...
I'm Subhasis Biswas from India.
Okay, can you tell us your name?
May I ask questions, sir?
Yes, please tell us your name and where you're joining from, and let us know the person to whom you would like to address your question.
I'm Subhasis Biswas from India.
Okay, thank you for joining us.
My question is, in all the construction contracts, it's almost mandatorily there is a provision of liquidated damages or penalties for delay on the contractors. Do you feel that similar laws for concern to contractors in case the employer or client delays the project? It's just for the balance platform, balance risk.
Okay, thank you for your question. Who would you like to address your question?
It may be Mr. Mitra or any other panelist.
Okay,
Because,
Mr. Mitra.
For me, the answer is more important. Yeah.
Mr. Mitra, the floor is yours.
On the liquidated damage matter, there's not much I have discussed on the liquidated damage matter, but perhaps I will ask Mr. Nwandem to talk about it. Mr. Nwandem, please.
Yes. So I was struggling to understand, to hear the question totally. So please, can you just repeat it so that I can I can answer your question?
Sure. My point is similar to liquidated damages. Do you feel that there should be a clause almost mandatorily mentioned in the contract that contractor also should be compensated in case the project gets delayed on account of employer or the project authority?
So thank you very much. So basically, like I said, your first point of reference is your contract. Basically, what the contractor has as a form of compensation, he has his entitlement to extension of time and prolongation costs, and those prolongation costs basically will compensate the contractor for costs he has incurred as a result of the employer cost event. So if, for instance, as a result of the delays, his projects were idle on, his equipment were idle on site, or he would need to spend more in terms of labor, in terms of materials to cover up the delayed period, he is definitely entitled to prolongation costs. But then again, like we say, it's not automatic. So entitlement needs to be substantiated. So you do that during the contract and most importantly in arbitration, because that's the same thing that happens. So definitely the contract has provisions, to compensate the contractor for employer cost delays.
I will add a few sentences on it, Mr. Nwandem, to Mr. Biswa's question. That's as Mrs. Okoko explained on FIDIC 8 and 20. This can be put together in a contract. Clause 8 and clause 20 of FIDIC, whether it's 99 or 2017. I think it's better 2017 because it's more process oriented and the time bars are more fixed in 2017. Therefore, this can be a real reciprocation in the contract, which are missing certain clauses as far as your question is concerned. Over.
Yeah.
Thank you
very much.
Yes, thank you so much, sir, for joining in and for weighing in with your thoughts. I will take Oluwole Farombi. Please forgive me if I mispronounce your name. I'm so sorry. I'll take Oluwole Farombi, please. You have the floor, Oluwole Farombi.
Thank you. Oluwole Farombi is my name. The session has quite been insightful, and I want to commend the organizers.
Where are you joining from, sir?
I'm calling from Nigeria, from Ilorin, Kwara State, Nigeria. I actually want to ask that for the FIDIC book, would it be appropriate to state that when there's a contract, there will be a particular or specific FIDIC book that will guide the contract? I mean, if there's a contractual, the contract to be entered into, will the employer have stated that this contract is being guided by FIDIC 1999, red, yellow, or silver, or like the last speaker actually commented that it would be better to state that 2017 suffices. So I just want to ask, is it appropriate to just generalize or specify the FIDIC year that is being guided by the contract?
Okay, if I could take that, a full complement of contracts that guide certain kinds of contracts. So if you had a build, operate, and transfer kind contract, for instance, it would be a different book. So there is the red book, there is the gold, the silver, the green, you know, so different books will guide different things. So it depends on the kind of construction you're doing, you know. So when Aninda is talking about 1999 or 2017, he's actually talking about updated versions, right? Rather than different kinds of contracts. I will look for a particular slide that will show you how to choose what, whilst any of my co-panelists talks even more about this. But whilst they're doing that, I will be looking for that slide, and then I can just display it very easily.
All right, Madam Diane, let me just jump in and also assist. So basically, the choice of a contract, as Madam Diane has said, is dependent on the needs of the employer. So basically, what we do is that we want to know the employer's expectation. So from the employer's expectation, we're able to guide. Do you want a silver book? For instance, a silver book is an EPC trunking contract, and we want to know basically what you want. So an EPC silver book, you basically wouldn't be you won't be involved in the day-to-day run of the project. So we want to know if you want to be involved in the project, and if you don't want to be involved in the project. Those are questions we want to ask. We also want you to know, the special nature of the project. An EPC turnkey project will be, you're looking at a plant construction or whatever, which will require specialist experience. And so you would want to, so we need to get your particulars. The particulars are going to be asking you your level of involvement in the construction. Do you want to handle the designs? If you want to handle the designs, then we'll look towards you having a FIDIC red book, which means you do the design and the contractor contract. So it's basically what you want. There are no bets, there are no best, there are no worst FIDIC books. So it's all about your expectations.
Well, I think the questions what the audience is asking should be limited to our core area of topic today about delays. And if we widen the scope too much, then we won't be within the time schedule. That's what I mean.
So this is just what Osinachi has mentioned. Will the contractor be responsible for this, this? If yes, then you know which book to choose, right? Is the contract relatively small value, completed within a relatively short period, then you know that you're looking at the green book, okay? So just so that you can see clearly in visuals what Osinachi just explained, you know, what we're saying when we talk about choosing which book to guide what kind of contract.
Okay. I believe Mr. Farumbi is satisfied with the responses. Mr. Farumbi?
Yeah.
All right, very good. Thank you so much. We have some questions in the chat, so I will just read them. There's the question here that says, and I think this is for Mr. Mitra, what is the difference between delay and disruptions? Because I recall in your presentation, you said disruption is not delay. So Showumi wants to know the difference.
This is something I left out. I must apologize for it, but it was quite well explained by Mr. Nwandem when he was explaining the slack part of it. Kitting defines float is the amount of time that non-critical activities can absorb over their original intended duration without impacting on the critical path of the works as a whole. This is the definition of float. Now, audience who are not expert on this wording of float, I think, we keep some kind of slack, some kind of flexibility in the program. Like in today's program, there are a certain mention of slippages. So we do keep some slippages and keep some areas where we can catch up. even on the productivity, let's say if you want to dig 100 cubic meters of soil, and theoretically it may take 5 hours, we can say let's put 5.5 or 5 hours, 15 minutes, something like that. These are the slacks, and these slacks finally generate to a kind of a float. There are many kinds of floats, intermediate floats, terminal floats. Now, these floats are kept intentionally just to play a little bit because nothing is theoretical. Now, certain disputes come in the contract. That's one of the major disputes come in the contract. Who owns the float? Now, with my experience of 30 years in the construction industry, let me tell you, take it for granted, it's a first come, first served basis as far as float is concerned. But the law doesn't support this one. I have mentioned in the chat group about case law, Ascon Contracting Limited versus Alfred McAlpine Construction Isle of Man Limited. Kindly read the case judgment, but in practical life, float is first come, first served basis. Now this disruption matter is coming in. Now, if it is within the, any delay is within what float can catch up, it's not critical. And that's kind of disruption. You can have a half a minute loss while you are doing a construction, but half a minute is deemed to be inside a contract, inside a planned program. So that's a disruption, and disruption is nothing to do with critical delay. A critical delay is only there, as I defined initially on my first slide about critical delay. Please have a look. I will repeat again about this critical delays to evade this misunderstanding between disruption. The sequence of activities through a project network from start to finish, the sum of whose duration determines the overall project duration, or in other words, the longest continuous path through the planned works. There can be more than one critical path for sure. So this is the basic difference between delay and disruption. And in construction law, we should not misuse these words or try to confuse this word. What is delay and what is disruption? They are entirely different aspects. If you're asking for a claim, if you're entitled for a claim and you write disruption, nobody will share with you any good thing about any kind of claim. So that's one of the questions I read in the chat message, and I think it explains to the audience who is asking the question. Another question came in, sharing certain clauses related to prevention of delays. Now, there is no clause to share to prevent delays. You just got to be smart. That's my subtle answer. Back to our moderator, please.
All right, thank you very much for weighing in with that. I believe that the questionnaire has been satisfied with that question. I'll take another question from the chat, and then I'll come to FCIArb. If disruption in an ongoing building construction project is caused by the employer to the extent that the work by the contractor is put in a halt for a quantified number of days with the contractor's personnel and machine running, will that not amount to delay if the contractor put a claim for extension of time and cost? I think Mr. Nwandem could speak to this.
Yes, yes, it amounts to delay. So when you say halt, you talk about suspension. So correct me if I'm wrong, but that's what I get. And when the employer suspends a project, a contract, performance of a contract for whatever reason, the contractor is entitled to extensions of time and costs. Definitely, he's entitled to that. The provisions of the provisions of the contract should do that. Should provide for that. So if your contract is hinged on the FIDIC book, so somewhere in subclause in clause 8 or so, I think subclause 8. I'm not, but around subclause 8.8, it provides for your entitlement to extension of time and to costs incurred owing to the employer's suspension or halting the contract. So definitely you put your claim. But then again, you should look at the 4 quadrants. ask yourself if you are doing it within the time provided under sub-clause 20.1. That's very key. So please don't forget those information. It could rid you of your entitlement. So.
Thank you so much for that. I believe that the questionnaire has been satisfied with that response. Thank you, Mr. Nwandem. I would come back to the House now. FCIArb, you have the floor for your question.
Thank you very much, Samuel. My question is to either Madam Diane or Osinachi. When you have a tribunal that is saddled with determining a claim, and the parties involved, the kind of contract they have was a bespoke contract and not necessarily a FIDIC contract, would the tribunal still be bound to look at what the FIDIC contract provides for in terms of the claim being sought or the reliefs being sought by the parties?
Okay, thank you, Efosa. I think this is a straightforward answer, and my response would be no. The tribunal will be guided by the FIDIC if need be. Remember that at every point, recourse is had to the contract between the parties. The breach, either contractual or maybe legal, would be a breach of the contract, remember. So it really is about the terms of the contract. It's about what the parties have agreed to be bound by that will guide the tribunal as to reaching that decision, whatever it is, as to who bears liability for what. That would be my, very short answer.
Thank you.
All right, thank you very much, ma'am. For want of time, we may have to round off. Time is fast spent already, but I'll just take one more question that we have in the chat here. This question is from Henry Chukwunonso Kamuke. It says, from your experiences in concluded and live matters, are parties better off with institutional arbitration or ad hoc arbitration when it comes to resolving the issue of delay? That's the first leg of the question. Then it continues by saying, this question is without prejudice to which way the decision or award may turn. Will parties win or lose? Will parties come without doubts that such arbitrator or panel really understood and determined the issue of delay? I think this question should be for Mrs. Okoko from the arbitrator's perspective.
Thank you, Samuel. Could you take that again, please?
Yes. It says, from your experiences in concluded and live matters, are parties better off with institutional arbitration or ad hoc arbitration when it comes to resolving the issue of delay? Okay, that's the first leg of it.
Heard that. So I'll take the first ambit, and then you can read out the second. Remember that when we talk about whether institutional or ad hoc arbitration, we're actually talking about the administration of arbitration, not necessarily the decision-making process. The decision-making process remains same. It's just about the administration of the process that you would think about, institutional or ad hoc. So I'd say that for as long as you have experienced, competent, industry-specific arbitrators, then you're fine either way, whether institutional or ad hoc, right? Your agreement will bind the parties, will guide the tribunal as to which way to sway in taking the decision. So I do not imagine that whether the arbitration is institutional or whether or not it's ad hoc, it would impact either way in helping your determination. The second bit, please.
Yes, the follow-up question to that is that, will parties come without doubts that such arbitrator or panel really understood and determined the issue of delay?
Yes, why not? Delay is really about construction arbitration is about knowledge and expertise in construction, not only arbitration, but of the construction industry itself. So remember that this is a very specialized industry. It's one where palances are used. It's like going into a room of lawyers when you are a medical doctor. You're certainly at sea. So you need to understand when the parties start talking about, the superstructure, the substructures, what exactly are they talking about? It takes industry knowledge to know these things. And quite honestly, in determining delay claims as an arbitrator, you would look to see how the counsel representing the party has sought to establish that a claim is justified in the circumstance. So Osinachi talks a lot about the contemporaneous documents, the pyramid, methodology in establishing claims. And remember when I told you when I showed you what the tribunal will be looking out for to see that you have put before them as counsel in an arbitration. So really, this is it. I don't see that it's anything different from understanding the industry.
Excellent, ma'am. Thank you so much, ma'am, for that wonderful response. And I believe that Mr. Nkamuke is satisfied with the responses. I'm so sorry, and I want to apologize, but we may not be able to take further questions for want of time. We look forward to other platforms where these questions can be addressed. I want to thank all the presenters for wonderful, intelligent, beautiful submissions at this webinar. And I think that people should already begin to look forward to watching after this, and of course the presentation slides, subject to the permission of the presenters. So we would very quickly proceed to take the vote of the closing remarks by the chapter chair, Honorable Shola Ephraim Uluwanuga, Chartered Arbitrator, for 2 minutes, please.
Well, quickly, I like to, this is indeed wonderful. I'd like to thank the speaker and the discussant for what they have done today. Also, Mrs. Nwosu and her team. What we have tried to do is to continue to build this foundation which others also have built or have been building, and that is for us to be better concerning construction law, which will now serve as a sine qua non for our construction arbitration practice. And good enough, Aninda, as also the jury is out there that there's something else coming, maybe termination of a construction contract or other topics will be with you soon. Let me just say, in rounding up, that this is just one of the SIG groups that we have in the chapter. You will recall last year that we did a program on PIA, that's the Petroleum Industry Act, by the Energy, Oil and Gas and the Power Group. And I'm sure, I know for certain, they are also working on something on the new Electricity Act. So we'll be coming to you with that. And then, of course, we have the public institution group working on something. But essentially, what we want you to do is to hold on, and the chapter will continue to call on you and to beckon to you whenever we need to continue this discourse. Once again, I want to thank everybody who has been part of this program, all those who are with us. We still maintain about 100 people on this platform, and we have other people also on the YouTube. We had about 350 people registering for this project, and we know that some of them are on the YouTube. So thank you very much. Over to you, moderator. I also must thank you. Thank you.
Thank you very much, sir. It's been a pleasure moderating the event, and we are rounding off now with vote of thanks and closing from the chair of the organizing committee, Mrs. Roslyn Nwosu, who is also the first vice chair of the Chartered Institute of Arbitrators, Abuja Chapter. Over to you, ma'am.
Thank you very much, Sam. It's been a wonderful time well spent. My duty is so simple, just to say thank you to each and every one of us. I want to thank our highly esteemed participants, that is all of us. I want to mention a few names. Please permit me to do so. I'll start by mentioning my Lord Honorable Justice Gladys Olotu of the Federal High Court. I'll also mention my Lord Honorable Justice Rolly Harriman, retired formerly of the Rivers State High Court. My Lord, you're retired, but not yet tired. We know how active you are. I want to thank both of you in a very special way for making out time to be here with us today. When we see people like you, it encourages us and helps us to keep on moving and keep on pushing. I also want to thank, in a very special way, our distinguished professors, Professor Emilia Onyama of SOAS, School of African and Oriental Studies, University of London, and Professor Charles Ilegbuna, our dear prof of so many years, formerly of the University of Nigeria, UNN Nsukka, and later of the University of Abuja. Thank you so much for being here with us. I'll now move on to our distinguished sales, Godwin Omaka, SAN, and Abdullahi Haruna. Thank you, sirs, for being here with us. You encourage us with your presence. I now go to my chair, the host, Honorable Shola Ephraim Oluwanuga, Chartered Arbitrator, Chair of FCIArb Abuja Chapter. Thank you, sir, for being here with us. You are our host. I know we can always count on you. Thank you for being there. I also want to appreciate Ms. Chinelo Agbala, Admin Secretary, FCIArb Nigeria Branch. Thank you, Chi, for being here with us. Thank you for your encouragement and for the various things you help us to put in place. Then to our erudite and distinguished lead speaker and the discussants, Mr. Aninda Mitra, MS Diane Okoko, FCIArb, and Mr. Osinachi Nwandem, FCIArb. I don't even know how to thank you. Your papers were so wonderful, so insightful, and I have learned quite a lot, and I believe I'm speaking for many of us who have been patient enough to wait, and I must commend the participants. They were very, very patient. Up till now, we have almost 100 people in place, plus all those ones that are viewing from the YouTube. Thank you so much, each and every one of us. Thank you. Thank you for being there, the participants for being here with us. Without you, we wouldn't have been able to, make any impact at all. Thank you for being participative, making it very lively. And for the many questions that we're not able to answer, please, we'll be able to, you can send them to us and we'll be able to reply. I also want to thank, I don't want to take my team members for granted. I thank each and every one of you, starting with Sam, the moderator. You did a wonderful job. Not that I expected less anyway, the team speaks for itself, so to say. We always know who will deliver. I also want to thank each and every member of the team, Max, Hawa, who am I forgetting? Sorry, Chair Mary, and each and every one of you. You were there for your hard work, for your dexterity in putting this together. It wasn't an easy thing, but we did it, we made it. So I want to thank each and every one of you. And then to all our participants, I do not know how to thank you, and I cannot thank you enough for being there for us and for your contributions. It made it so lively and worth our effort, worth the while. Thank you so much. And please, when we invite you next time, do make sure that you come, because as my chair has said, and the lead speaker, we have a lot of things, planned along this line. This is the specialized area, and the more information and skills we acquire, the better for each and every one of us. Thank you so much for coming. God bless each and every one of you. Thank you.
Thank you very much, ma'am. Yes, we celebrate you. I can see Honorable clapping for you. Thank you so much, ma'am, for covering the field. As we close, I would want to thank all the participants on Facebook, on YouTube, on Zoom for joining in, for spending time with us. I know it's been an insightful time. I also want to thank our hosts and everyone, the branch chair, the chapter chair, our SIG chair, the chair of the planning committee, our lead speaker, and our eminent discussants for such a formidable webinar. A lot of comments are already coming in and feedback that it was an excellent webinar. We thank you so much for joining in. We'll wrap this up now and we look forward to subsequent webinars. And like Mrs. Nwosu has said, FCIArb, when we call you again, please do well to join us. Thank you so much and do have a wonderful evening. Bye, everyone.
Bye, everyone.